Thank you for the introduction, Orla, and good evening to everybody who's logged on to this short short webinar on from the Office of Environmental Protection. As Orla has rightly stated, our principal role is the protection and improvement of Northern Ireland's environment, and obviously the wording of the legislation covers not only Northern Ireland but England, but excludes Wales and Scotland, who have their own specific bodies carrying out similar or aligned functions to the Office of Environmental Protection. What I intend to do tonight is basically to introduce you to the Office of Environmental Protection and its principal operations, and how it works, and happy to take any questions at the end of the presentation. As Orla said, I'm the Principal Monitoring Environmental Law Officer on the Monitoring and Environmental Law and Advice team. And while based in Northern Ireland, my functions include both Northern Ireland and England. And I have only been with the Office of Environmental Protection for nearly 6 months now. So what is the OEP? The OEP was established under the Environment Act as a new public body, and it's quite unusual to see new public bodies being set up, particularly in the current government framework. The role of the OEP is very strictly aligned to the legislation and to the Act, but principally it's to protect and improve the environment by holding government and public authorities to account against their commitments and implementation of environmental law. The remit covers England and the primary legislation, and Northern Ireland under Schedule 3 of the legislation, and other reserved matters. The OEP is central to a new system of environmental governance in the Environment Act, which includes environmental improvement plans and the monitoring of targets and environmental principles. The Environment Act, for any of you who are very keen to read the legislation, is freely available from the various legislative websites. It is a long document, and you will find within it all of the principal initiations of the OEP and what it is legally required to undertake. So we have to look really at from a point of view of what does the OEP do? What have we started doing? What have we begun to complete? Broadly under 4 different categories. One is scrutinizing environmental improvement plans, EIPs and targets. And as you'll be aware, the OEP, or as you may or may not be aware, the OEP has published its own review of the UK government's 25-year environment plan, and looked at these very ambitious targets and monitored progress against them. We have a function in scrutinizing environmental law, where we look at the way that public authorities and government bodies have been both implementing and developing environmental law, and we will determine and evaluate the effectiveness of that aspect of their work. For example, I'm currently working on a review of river basin management plans in the water environment, and looking at both the regulatory structure and their implementation, and of course then what the final results and any missing parts to the puzzle are. We have a role to advise government on proposed changes to environmental law and other matters related to natural environment. And lastly, but probably best known, we have an enforcement function where we will investigate suspected and serious failures to comply with environmental law by public authorities and enforce compliance where that is needed. Like all all public bodies, the OEP has a strategy. Excuse me. Its principal objective, obviously, is to contribute to environmental protection and the improvement of the natural environment. Within that strategy, we undertake to act objectively and impartially. We will also act proportionately and transparently. As part of that proportionality, we have published our own enforcement policy on our website, and we have working arrangements with a large number of other public bodies to ensure that where there is overlap, that overlap is in partnership and that there is no duplication of resources. Our strategic objectives really set out as sustained environmental improvement, better environmental law and better implementation of environmental law, improved compliance with environmental law, and organizational excellence and influence from within the Office of Environmental Protection. As a public body, we were required to publish a corporate plan and set out our program for our first year. It was published in June 2022, and our priority work was on nature recovery, air quality, water quality, soil management and soil quality, and the marine environment. And all of those different work packages are at different phases and different levels of development. How we decide what we're going to do, how do we reach those? The priority was based on 4 principles. By the outcome and across our functions so that our work makes the most difference. By judgment supported by the evidence available at the time. The priorities really have to consider how large an effect could our action have? How likely is our ability to have that effect? Whether it's a strategic fit, and what is our capacity and capability to deliver? And obviously we will be transparent about what we deem to prioritize. In terms of capacity, the OEP is a relatively young and relatively small organization. And quite often we have to be very careful to ensure that we have the capacity, capability, and technical knowledge to deliver what we want to deliver. Many people in discussion prior to this webinar have been focused very much on our approach to enforcement and what the OEP is likely to, what approach the OEP is likely to take to enforcement. Obviously, our aim will always be to seek the best outcome for the environment. And we have a range of options that allow us to escalate our enforcement activity as necessary to achieve the desired outcome. And sometimes a non-statutory intervention produces a better result than a statutory one. In order for us to launch investigations, we must have information that suggests a public authority has breached environmental law, and if so, that failure of the public authority would be serious in nature. Our enforcement options as laid down under the Environment Act include information notices, decision notices, and of course, high court action. And no enforcement is undertaken without serious consideration and evaluation of its effectiveness. In terms of complaints, a person can make a complaint to the OEP if they believe that a public authority has failed to comply with environmental law. If you feel a public authority has failed to comply with environmental law, then the OEP will evaluate your complaint, and I will explain how the evaluation takes place in a moment. Some complaints which are outside of the OEP's remit can go to local government, social care and ombudsman, local government, social care ombudsman, if that is the right fit for them. To validate a complaint must be about a breach of environmental law. The environmental law in question should relate to England, Northern Ireland, or a reserved matter. The complaint has to be about a public authority. One public authority cannot complain about another public authority to the OEP. An applicable internal complaints procedure of the public authority complained about must have been exhausted, and complaints must be made within a specified time limit. The key issue really here is that for a lot of the communication I have with stakeholders personally, they wish to launch complaints at a very early stage without having completed or referenced the public authority's own complaints procedure, and that limits the amount of input that the Office for Environmental Protection can have. We have a sort of 7-stage listed complaints process. Again, this emphasis that the OEP can only evaluate complaints when the public authority's complaint procedure has been exhausted. If you then wish to make a complaint, there's an online form on the OEP's website, and the OEP will then check that the complaint meets the 6 validation criteria we earlier looked at. The OEP will assess the complaint in detail, decide to investigate, begin the investigation, and hopefully come to an outcome. Part of the assessment is a much more detailed look at the complaint. The primary purpose of this is to assess the seriousness and establish whether further investigation is a priority for the OEP in line with our enforcement policy. One of the slightly difficult and possibly controversial to some aspects of the Environment Act 2021 is a duty to cooperate. So when we ask a public body for specific information, whether that is on a complaints basis or a monitoring environmental law basis, there is a requirement under Section 27 of the Environment Act that says a person whose functions include functions of a public nature must cooperate with the OEP and give it such reasonable assistance as it requests, including the provision of information in connection with the exercise of its functions under this Act. This duty to cooperate for public authorities probably sits alongside freedom of information requests, environmental information requests. That type of detail is required under Section 27 of the Environment Act. To give you a little bit of a understanding of the number of complaints that OEP have received, since January 2021, we have received 84 complaints and one non-complaint that precipitated a self-initiated investigation by ourselves. Of those complaints, 5 are currently being validated to determine whether they're eligible, and 38 closed have been validated for not meeting the criteria that we talked about earlier. In total, 42 complaints have met the criteria for complaining to the OEP, as well as the one self-initiated assessment. The current assessment statuses are as follows. 1 hasn't started, 8 are in process, 22 have no further action. This was mainly due to there being no evidence that the public authority had failed to comply with environmental law, and those were closed. 2 interventions have been sent, 1 investigation was launched, and 1 investigation has been proposed to our board. Obviously, those numbers don't all add up because sometimes we get the same complaint from different people, and sometimes we take some of the complaints that come in and amalgamate them if they're in relation to the same topic. In relation to what people are complaining about, obviously local authorities still represent the most common public authorities complained about, followed by the Environment Agency in England, with pollution control and nature conservation being the most common topics of concern. There are also other topics of concern, including broad governance, waste and resource use, and monitoring and assessment. So to summarize, if there's a complaint about an alleged failure, the complaint will be validated to determine it fulfills the OEP's functions. We will determine if it's serious and then investigate. And that investigation may precipitate, if it's urgent, a judicial review. If it is serious but not urgent, then we may serve an information notice, a decision notice, or an environmental review. We consider that court action should be the last resort, but we will take that court action where a public authority contests our conclusion that they failed to comply with environmental law, where a public authority did not implement our recommendations from a decision notice, or did not implement them in a timely manner, or where a public authority accepts its breach but disputes the remedial steps that we suggest. We can only request an environmental review where we have previously issued an information and decision notice. Where a case is assessed as having potential for serious harm, the OEP may apply for urgent judicial review or statutory review, where it considers doing so as necessary to prevent or mitigate serious damage to the natural environment or human health. Away from complaints, a number of OEP staff are involved in scrutinizing environmental law and delivering appropriate advice. The regulation requires that OEP must monitor the implementation of environmental law, advise ministers on request regarding proposed changes to environmental law and matters relating to environmental law, and the OEP may report on matters concerned with the implementation of environmental law, advise ministers on its own initiative about proposed changes to environmental law, and we may ask local authorities to provide information to us or bring matters to our attention. One of the main pieces of environmental improvement targets was the 25-year environment plan, which was the first of the government's environmental improvement plans, which was reviewed in 2023. The OEP has a role to monitor the government's progress against EIP, against environmental improvement plans. And OEP has published that in review of the first monitoring report of the 25-year environmental plan, while we recognise the plan's ambition, but felt that progress had been slow, and we pressed the government now to take stock and take a purposeful, coherent, and decisive action so the environment is restored, protected, or enhanced for future generations. Our annual reporting cycle, with the first report published in May 2021. Part of our statutory duties is hold government to account on environmental progress, and we will set out in our next annual report what is required for the national level of environmental stewardship. Part of that understanding is understanding the pressures and drivers, creating a vision, the setting of targets, having coherent strategy and policy, looking at governance, and measuring, assessing, and reporting. We will work with other government bodies and public authorities in different ways to ensure that we comply with our legislative function. We also have taken a very in-depth engagement from our stakeholders, and we will engage, listen, and learn from stakeholders, drawing on respecting the deep technical expertise of specialist bodies, including those in government. For example, I have organized a stakeholder group to look at river basin management plans, and rather than take the view that all of the stakeholders were NGO type bodies, that stakeholder group has both professional bodies, NGOs, as well as government departments, all represented on that group and all sitting around the virtual table together to discuss those issues of interest in relation to river basin management planning. As a new organization, we have to earn the trust and respect of all the organizations we work with, which we intend to do by being independent, objective, impartial, and reliable. The key milestones for 2023, the new environmental improvement plan, significant improvement test, proposed targets, environmental principles adoption, and the detailed and extensive list of the reformed EU law bill and how that is going to progress. And we're developing 3- and 5-year plans for the OEP. The OEP have a website as detailed there, and a lot of information about the OEP, its functions and its publications can easily be accessed there. In terms of Northern Ireland, we have a large number of staff. We've in the region of 9 or 10 staff now in Northern Ireland, working across different functions within the OEP. Those staff are looking at Northern Ireland complaints. They're looking at monitoring environmental law in Northern Ireland, and quite often looking at both Northern Ireland and England. We are intending to extend and expand our general stakeholder engagement in Northern Ireland. And I would invite anybody with concerns to get in contact. In Northern Ireland terms, if you wish to use myself as a gateway, I'm quite happy to ensure that your concerns are directed to the appropriate person or section within the Office of Environmental Protection. And that, with that point, I would thank you for your attention, and I'm happy to take any questions that may be posed.
Hello, everybody. I'm Conor McKeown from Water Solutions Ireland, and tonight I'm going to be fielding some questions to John. John, there's a few questions have come in here, so I'll probably just start at the top, if that's okay. So the first one is from Matt Armitage, and it says, with the OEP having remit over jurisdictions that are covered by the Environmental Agency, what are the principal differences between the two bodies?
I'm sorry, Conor, I didn't quite catch the question there.
No problem, John. I'll just repeat the question if that's okay. With the OEP having remit over jurisdictions that are covered by the Environmental Agency, what are the principal differences between the two bodies?
I'm assuming that the reference there is the difference between the Environment Agency and Northern Ireland Environment Agency as the two different bodies. Structurally, they're very similar. The legislative framework for both bodies is very similar. Probably the biggest difference is the differentiation in Northern Ireland between flood risk, which is under the Department for Infrastructure, whereas that is actually contained within the broader Environment Agency body.
Okay, John. The next question is from Christopher Calder, and it says, OEP is to hold government to account. Is it envisaged that this could include the NI executive? If so, would this include underfunding of organisations who have actions to deliver for water quality or other environmental improvements needed to meet targets?
I think one of the big issues at the moment in Northern Ireland terms is that some of the requirements under legislation have been completed by the executive agencies and gone to the Northern Ireland Executive, to the Minister of the Northern Ireland Executive, and that the collapse or lack of an assembly has actually stopped those from reaching the next stage, which is executive discussion on cross-cutting issues before they're finally ratified. And as such, we look and hope that we can find a way that, particularly on the water-based issues, that these plans can be ratified and then implemented in the way that they were designed.
Okay, thanks, John. John, I've got another few questions just coming in. I'll just keep asking if that's okay. The next question is, are all sections of the Environmental Act enacted in Northern Ireland?
If you're very keen to read the Environment Act, then go to Schedule 3, which is the Northern Ireland section of is where the Northern Ireland is brought into the Environment Act. But the majority of environmental improvement and environmental management aspects apply both to England and Northern Ireland. There are some aspects within the Environment Act not relating to directly the OEP that are not included for Northern Ireland.
Okay, thanks, John. John, just one more question. Let's see here. It's sort of, sorry about this here. It's just jumped around a wee bit. So what can we, where can we see the outcome of the decisions made by the OEP? And what has the OEP decided about the very large open cast metal mines in Derry, Tyrone areas? Both are catchment areas of Erne and Shannon.
First of all, in terms of the decisions made by OEP, they are transparent. They're published on our website and included in our annual progress reports. In terms of specific issues, I would be unable to answer
Okay.
on those at this time. But if the questioner wishes to put those concerns in writing to the OEP, I'm sure that somebody will be able to give them a proper and detailed answer.
Okay, thanks, John. John, I think I've just one more question for you. I'll just keep an eye on this here because they keep popping in as we talk. One question is mentioned doing a review of the River Basin Management Plan. Can you potentially expand on this? And are there any other key area notes included in reviews within NI?
Yeah, the River Basin Management Plan review is underway, and what we're looking at is a detailed review of the legislative framework, how that legislative framework is implemented, and what it means in terms of improvements for the water environment in Northern Ireland. We have taken, in terms of the water environment in Northern Ireland and the River Basin Management Plan, we've also begun to look at what we call international comparisons work. That's comparisons with the progress of river basin management plans and water quality in Northern Ireland with other EU jurisdictions and with other jurisdictions outside the EU to see if there are lessons to be learned from other methods of governance in the water environment. We've also taken a detailed look at existing and emerging pollutants within that project, and we have evaluated a number of persistent environmental pollutants that we are concerned about. In addition to that, more recently, I have begun to build in a separate project on bathing water and bathing water quality, both coastal and in river swimming activities. Within that project, as while the river basin management plans fall under the Broad Water Framework Directive regulatory remit, and while bathing waters fall under a different initiating directive from the EU, the objectives and the outcomes in terms of good, clean water quality are very similar. So I have begun to look in detail at that as well.
Okay, thanks, John. Let's see, John, there's one more that's just popped in here. It says, what will happen to EU environmental law in Northern Ireland?
Northern Ireland, like England, is going to be part of the reformed EU law bill. And I was looking at that this afternoon. My understanding is that all the environmental law that was derived from the European from Europe will be evaluated under the reformed EU law bill, and that includes Northern Ireland as well as England.
Okay, thanks, John. John, I'll probably finish with this question here. They're coming in a bit heavy at the moment. It says, is the OEP a statutory consultee for the likes of infrastructure works?
The OEP will look at specific consultations, mostly in relation to environmental law and environmental policy, only if a particular infrastructure, proposed infrastructure is raising concern, will the OEP look at that specifically?
Okay. Let's see, John. Maybe just one more. It says there is a planning preference for businesses development over and preceding environmental or heritage areas. Does the OEP look again at this objectively?
The OEP will look at protected sites and to ensure that any policy or procedure in relation to those protected sites is carried out in accordance with the regulatory framework.
Okay.
And again, under the Habitats Directive and other pieces of legislation, there is a comprehensive regulatory framework for that to be undertaken.
Okay. Okay. Well, I think, John, maybe we could leave it at that for the questions. I think that's answers all the questions that have come in. I'm sure if people have questions coming up going forward, they can maybe post them directly to you, John, or to the OEP, or somebody can maybe answer it. So I'll hand you over to Orla for some closing comments, if that's okay.
That's fine. Thank you very much.
Thanks, John.
Certainly. So yes, just to close out now at the end of our webinar, just to convey our thanks to John for coming and stepping forward and delivering our webinar for us this evening. I have found it really interesting myself, and hopefully everyone attending tonight has. So thank you very much, and hopefully again, this is the first year the OEP in its infancy still, that hopefully in following years now we can get John or somebody from OEP back as you embed in and work through the environmental issues within Northern Ireland. I'd also like to thank Connor, who's a member of our CIWEM committee, for helping me with the questions, and for Barbara, who always does all the hosting of our events from CIWEM HQ. So thank you all very much, and I hope I'll see many of those maybe attending tonight at our annual dinner and at future events. So thank you very much indeed.
I'd just like to thank the Northern Ireland branch for arranging this interesting talk, and also to John for speaking at it. As I said, I'm sure that there'll be a lot of follow-up on what the OEP is doing once we progress further.
Thank you, everyone.